Vodacom has settled with Nkosana Makate. It appears that another party claims it is entitled to 40% of that award. According to reports, a company called BlackRock Mining, which is registered in the British Virgin Islands, says there is an agreement that's currently in place to this effect, and that agreement was signed in 2011 when Makate's legal battle seemed financially insurmountable. Now, under the said agreement, the company was to cover all litigation costs in exchange for 40% of any eventual award. For more on this, we joined on the line by BlackRock Mining's attorney, Sinenhlanhla Mnguni. A very good afternoon to you, Sinenhlanhla. Welcome to Africa in Business.
Good afternoon, Thami. Thank you for having me on your show.
So give us a little bit of background as to who you are as BlackRock Mining and why it is that you are surfacing now.
I think I just need to clarify that I am the attorney for BlackRock Mining. I'm not myself personally invested in BlackRock. However, BlackRock Mining is a litigation funder. As you would know, it's registered in the British Virgin Islands, and they've financed a number of other cases in as far as where people required litigation financing. Now, in 2011, Mr. Makate went to or approached the directors of BlackRock Mining with a view of obtaining financing or funding for his litigation against Vodacom, which has now, of course, been popularly known as the Please Call Me case.
Right. So this agreement, you say, was signed in 2011?
Yes, it was. It was signed in 2011.
All right.
In fact, it was attached to a letter of demand which we sent to the attorneys for Vodacom and Mr. Makate's attorneys. I think my understanding is that that letter has since been leaked and it's publicly available.
Right. So could you summarize the key terms of that 2011 agreement?
In essence, our client would provide funding for Mr. Makate's litigation against Vodacom, and in exchange for that, our client would be entitled to 40% of the proceeds of whatever amount the parties ultimately settled at, or whatever was paid to Mr. Makate following a successful outcome via the court processes.
And did the company provide funding for that litigation?
That is our submission. Yes, that is our submission. They did do so.
They did provide the funding.
Yeah.
Right. So it is reported that Makate's legal team say that deal was terminated in 2015. Is that something that you dispute?
Yeah, that's been disputed over. I mean, aside from the Vodacom Please Call Me case, there's been litigation between the parties for some time now. It's not something that's new. The litigation's pretty much been ongoing since that 2015 date. However, as we state, we believe that there is valid performance from our side and our client, and we feel that our client should therefore be compensated with the 40% that is entitled to.
All right, so let me see if I understand this. So you're alleging that in 2011, the agreement was signed, that the company BlackRock Mining did contribute towards at least a portion of the litigation costs. According to Makate's legal team, that particular agreement that was signed in 2011 was terminated in 2015. Was there further engagement or further payments that were made by BlackRock Mining to Makate's legal costs post 2015?
There was definitely further engagement. There was attempted to make payments. Of course, there were issues. The matter is quite complex, and it's very difficult to encapsulate in such a short period of time. But our submission is that our client was in essence forced out and denied the opportunity of performing in terms of the agreement. And that was done strategically by parties. And we're not saying necessarily that it was only Mr. Makate's doing. You must understand there are various parties involved in this matter, and it's not just an issue between BlackRock and Makate. There are other parties that are involved. So it's very difficult to encapsulate in a few words. But we are ultimately saying that our client performed in terms of the agreement, in terms of fulfilling all its obligations.
So there are some legal commentators who question the practicality of enforcing this agreement, and that is given its age and the prior judicial references to its termination. How do you respond to these concerns regarding the age of the agreement and these prior judicial statements?
Oh, but the age of the agreement is irrelevant here. I don't know how the age of the agreement has any relevance. It's not like you can argue prescription, because an agreement is only terminated once all its obligations have been fulfilled or extinguished, or alternatively, if in terms of a termination clause that is cancelled. So the age thing is irrelevant and nonsensical. In as far as sorry, I missed the second part of your question.
It was around the judicial statements.
Oh, no, sorry. You mentioned the 2015 termination. Again, like we say, that's in dispute. There's been various ongoing litigation processes since then. There's been arbitrations and so forth. So that's a dispute. It's not something that's factual. It's not like there's a court order which has found that Mr. Makate validly cancelled the agreement. That's not the case.
So there is no paper trail of that termination. Is that what you're saying?
No, what I'm saying is this. Ultimately, a court has to adjudicate whether an agreement was validly cancelled or not. It's not for me or you to determine whether it was cancelled. If I dispute your termination, and this is at best case for Mr. Makate, if we say he did do that, it's still not, it can still then be ratified by a court through a court order. Ultimately, the courts are the final arbiters of legal disputes.
So what is it that BlackRock is wanting at the moment? Is your client wanting that 40% that was originally within the original agreement, even though they didn't take this particular case all the way up until the end? Or is your client wanting perhaps a reimbursement plus interest over what they spent on this case?
Very good question. Very good question. So ultimately, my client argues that it was constructively impeded from performing in terms of the agreement for whatever reasons the parties sought to obtain. And ultimately, we initially laid out millions of rands in order to fund this litigation. And I think my client's biggest concern and bone of contention is that at some point, parties saw that there was a fortune to be made, and they elected to eliminate my client from benefiting from this agreement, wherein my client had acted in good faith to, lend money or fund the litigation case of Mr. Makate at its inception.
So is the crux of your case being forced out?
Yeah.
Right. Is BlackRock open to mediation or settlement discussion, and under what terms might the company consider an alternative resolution?
Look, ultimately, I'm not the spokesperson for BlackRock. I'm the attorney for BlackRock. So I would be speaking out of turn in as far as mediation and settlement. But certainly, knowing the clients that I do have in BlackRock, they're reasonable people. So I don't think I'm speaking beyond my mandate in saying they are open to some sort of a sit down and a discussion with Mr. Makate to see how we can find each other with regards to resolving this matter going forward.
And what is going forward looking like?
Look, it's ultimately not what we want to do, but it looks like our client will be bringing an urgent court application to interdict the payment from Vodacom to Mr. Makate.
And do you know how much we're talking about?
Discuss, unfortunately, I would be exposing myself to significant risk in as far as the agreements between the parties.
But do the parties know, as in does your client know what the figure is?
My client doesn't know, and we haven't ventured to establish that amount as of yet, because we understand, of course, and we've been advised via correspondence from the attorneys of Vodacom and Mr. Makate that is subject to a confidentiality clause in the agreement. So no, not at this stage, but it's something that we intend to uncover through the various court processes that we intend issuing.
All right. Well, thank you so much, Mr. Sinenhlanhla Mnguni. We'll certainly be keeping abreast of developments on this case.
All right. Thank you very much.
Thank you, sir. That's Sinenhlanhla Mnguni. He is the attorney for BlackRock Mining.